Members of the jury, we're going to take a 20-minute break, and just for your information, we'll also take a 20-minute break after the defense argument, before the state's rebuttal and the final instructions.
All right, Lou, we're taking a 20-minute break now. We just listened to Steve Schlischer give the closing arguments, I should say, for the state side. What are your immediate impressions?
Well, he spent a lot of time going through everything that happened. He went through what happened, what a lot of the witnesses testified to. He spent a lot of time going piece by piece on what needs to be proven for each charge and each element of each charge. And then he ended with telling the jury to trust their eyes. That was kind of a theme of the entire prosecution here, is to believe what they see and use common sense. And so that was kind of the entire theme of it. I would love to get reaction from our attorney guests on, I guess, to rate the performance of it and so forth. But overall, I think that the prosecution got its point across over nearly 2 hours of an opening statement there.
I was going to say it did take nearly 2 hours, and it seemed to meander for a while. It got a little more focused towards the end, a little more emotional towards the end. And one of the last things he said is what you mentioned. This case is exactly what you saw with your eyes. It's what you know in your heart. Those are some strong words.
Absolutely. So why don't we bring in our first guest? We have defense attorney A.L. Brown joining us today. Thanks for joining us, A.L.
Good morning.
Good morning.
Or good afternoon, is it already?
Getting close.
I'm not sure anymore.
Getting close. Well, A.L., tell me your initial thoughts on what we watched this morning.
Well, we heard the state use the phrase unreasonable and excessive, and at some point I started to wonder if they were describing the closing. It just went too long. And there was, I'm very hopeful that the rebuttal on this case will kind of focus the jury into what is just gold on the floor left in the trial courtroom during the course of this trial. Help them see the bigger picture. This is, again, I always say I'm a defense attorney, so I've got a different perspective, but I think the state has a habit that they cannot seem to break of boring the bejesus out of anyone, no matter how good the plot, no matter how good the evidence. What we just witnessed, I think, was probably going to be disappointing, not only to the Floyd family, who has so much built on this closing argument, but also to the community at large. This is probably Eric Nelson's most confident moment during the trial, and it's by operation of the closing argument we just heard. Will it ultimately prevail? Maybe, but there were so many other ways to spend 2 hours today on such an important issue, and I don't think it was a good use of our time.
And so, A.L., can you give us some specifics of where you think they should have spent more of their time and where they should have spent less of their time in that opening statement?
Well, I think it's about less time. For instance, I don't understand for the life of me why they are arguing the state's case. Why? You have a rebuttal. I'm sorry, arguing the defense's case. You have a rebuttal coming. You have an opportunity. Whatever Eric Nelson says about Mr. Chauvin, you've got Jerry Blackwell coming right behind him to say, that's nonsense, that's foolishness, here's why that's wrong, that's silly. You see all the silly stuff they put up against the wall? That's because they don't want you to believe your eyes. So why in the world would you spend all the...
Okay. We have some technical difficulties there, Lou. So
Yep. So we'll get back to A.L. in just a second. Why don't we take a listen back at some of Steve Schlischer's opening statement first?
He begged, George Floyd begged until he could speak no more, and the defendant continued this assault. When he was unable to speak, the defendant continued. When he was unable to breathe, the defendant continued beyond the point that he had a pulse. Beyond the point that he had a pulse, the defendant continued this assault. 9 minutes and 29 seconds. When the ambulance arrived, The ambulance was here. And the defendant continued. He stayed on top of him. He would not get up. He would not let up. He stayed on him, grinding into him, continuing to twist his fingers, to hold him down. He had no pulse. He was not breathing. He was not responsive, and the defendant had to know what was right beneath him. Right beneath him. The defendant was a police officer. He was. And again, you need to set aside the notion that it's impossible for a police officer to do something like this. The defendant is on trial not for being a police officer. It's not the state versus the police. He's not on trial for who he was. He's on trial for what he did. That is what he did. That is what he did on that day. 9 minutes and 29 seconds. That is what he did. He didn't follow training, those hundreds of hours of training that he had. He did not follow the department's use of force rules. He did not perform CPR. He knew better. He just didn't do better.
And so, AL, glad to have you back with us here. You froze up a little bit mid-sentence there, so we definitely want to hear the rest of your thought. And also, if you could comment on kind of the strategy that Steve Slisher used as far as separating Derek Chauvin from the rest of police. He said a couple times that police are not on trial here. Like, this bad police is on trial here is the way that he put it to the jury.
Completely unnecessary, to quote Lieutenant Zimmerman, to make that separation. Why not take advantage of that opportunity to say what everyone on the jury already knows? There's been a subsequent killing in the Twin Cities. They know there's a problem. Just as a matter of strategy, why take that away? Here's the point I wanted to make, Lou, about arguing the defense's case in your primary opening, in your primary closing. You've got Jerry Blackwell, who's going to come back and clean all of whatever Eric Nelson says up. Why not focus on your great case? You have more gems to show the jury. You have an embarrassment of good evidence, from scientific to having the chief of police testify. You've got this video that is so compelling that only a prosecutor could mess it up, okay? So that's where we are with this. I really hope that for all of those who believe that there should be a conviction based on the evidence that we've seen, the jurors that are sitting at home, so to speak, I hope that there's some serious cleanup done on rebuttal. I didn't like at all the idea that he was suggesting that I think he said, this is where the excessive force began. No, the excessive force began the moment the cop showed up on a $20 ticket, a $20 fraudulent case, and tapped the window with a gun. Why do you start the excessive force so far into the abuse? The excessive force started when the cop shows up and is swearing at the man. That's when the excessive force starts. We have to reframe and rethink, and maybe the state isn't the right entity to do it, exactly what excessive force is, how police are supposed to interact with the people they are protecting.
AL, a couple of moments that I felt were a little unusual is when he classified this as a pro-police prosecution. There were a couple of jokes in there. It meandered for a while. It did get more pointed towards the end. Do you feel like the state was able to get the point across? They went through each charge, second-degree murder, third-degree murder, second-degree manslaughter, and why they felt like they proved that Derek Chauvin was guilty. Do you think they got that point across to the jury? And do you think you've made it clear, what you think about these closing arguments. Do you think that weighs on the jury as well? Or do they just look at all the evidence?
I hope that the prior days in trial will sustain the jury's verdict, whatever it is. Closing arguments are just critical. This is just such a huge missed opportunity and such a huge hole created for Eric Nelson to stand up and shine and offer a more concise theory of why his client should not be convicted. Now, based on the evidence I've seen, I wouldn't buy it. But this is America. This is a police officer on trial. and the defendant is Black. We got problems with this case at this point.
All right, A.L. Brown, we thank you so much for your insight, and we'll be checking back with you in just a little bit. Let's bring in now our guest who's in the KARE 11 with us today. This is Brock Hunter, defense attorney from the Twin Cities. Brock, thanks again for joining us today.
Thank you, Lou.
First of all, give me your thoughts on the opening statement, the job done by prosecutor Steve Slisher for the state.
Well, I agree with Rena that it did meander for a while, and it definitely went longer than I think we would have anticipated. I think the state chose to devote this first section of their closing to a more methodical examination of the evidence and specifically going into the elements from the jury instructions and making sure the jury had a framework from which to consider all of this evidence. I thought the use of that chart, the elements chart, as Steve Slisher referred to it, I thought was helpful because this is complex. These various elements of the charged offenses are complicated, and I think it was helpful to provide a framework for the jury to analyze the rest of this evidence. And I do think that Steve gained steam over the course of the closing argument, and we had some of that emotional impact that I think attorneys are always shooting for in closing arguments towards the end. I would expect that Jerry Blackwell is going to be the exclamation point, the emotional exclamation point for the state's case in his rebuttal. I think the state probably chose to go methodical on this first one and to save the power and the emotion really for their rebuttal. That's my guess at this point.
Okay, and Brock, I want to take a listen back at how Steve Slisher closed his closing argument, his very last bit of how he brought it around and ended it. Let's take a listen back.
You have that power, and only you have the power to convict the defendant of these crimes, and in so doing declare that this use of force was unreasonable. It was excessive. It was grossly disproportionate. It is not an excuse for the shocking abuse that you saw with your own eyes. And you can believe your own eyes. This case is exactly what you thought when you saw it first, when you saw that video. It is exactly that. You can believe your eyes. It's exactly what you believed. It's exactly what you saw with your eyes. It's exactly what you knew. It's what you felt in your gut. It's what you now know in your heart. This wasn't policing. This was murder. The defendant is guilty of all 3 counts. All of them. And there's no excuse.
So Brock, I'm curious how you thought Steve Slisher ended his closing argument. And also, we talked earlier about these elements. Now that we see them all laid out, were some of these elements that the judge decided on favorable to the state in what they want for the jury?
Sure, Lou. Well, first of all, I think the way that Steve Slisher ended it was powerful. Again, it took a while to get there, but I was struck by him first empowering the bystanders, the folks as they showed them on surveillance video, making their each individual way to the site where they would witness George Floyd's death. I thought that was emotionally compelling, and then he talked about how each of those bystanders did whatever they could under the circumstances, taking video, collecting their memories, and then coming into court and sharing their experiences. And then he transitions over to the jury and sort of puts them in the shoes of the bystanders and says, you randomly found your way here now to this trial, and you have power. You have power to take this evidence and reach the conclusion that George Floyd was murdered. I thought that was pretty powerful. With respect to the elements, yes, I do think that the judge's ruling, particularly on the definition of substantial bodily harm for third-degree assault, was critical in favor of the state. As you recall, to prove up second-degree murder, the state has to show that Derek Chauvin caused the death of George Floyd in the course of committing a felony third-degree assault. And as Steve Slisher adapted adapted the judge's jury instructions to the definition of substantial bodily harm. He pointed out that a temporary loss of consciousness under the definitions provided by the judge constitutes substantial bodily harm. So he provided the jury with a toehold, so to speak, to find that underlying felony assault and find Derek Chauvin guilty of the most serious charge of second-degree unintentional murder.
And Brock, let's go over the other charges as well, because there are the 3 charges. There is the third-degree murder and the second-degree manslaughter. And Slisher did the same thing, where he walked the jury through why he feels the state has proven those things. Did you feel like that they were able to prove those things to that jury?
I think the state has a strong case for all 3 of these charges. As I said, I think the toughest reach for them was going to be the second-degree murder. The judge's instruction on substantial bodily harm, I think, gives them a good basis to get that. I think third-degree murder and second-degree manslaughter are more easily within reach under these circumstances. And again, yeah, I think the state definitely has put evidence in front of the jury that the jury could reasonably use to convict Derek Chauvin on all 3 counts.
Okay, Brock, thank you very much for your help, and we'll be checking back with you in just a little bit.
Thank you, Lou.
And we also have former Assistant U.S. Attorney Doug Kelley is joining us today. So, Doug, having listened to the opening statement, briefly give us your thoughts.
Well, I share AL's impatience with the methodical method that Steve used, but I do see a larger plan here. And that is, the plan is to obviously have the crescendo be with Jerry Blackwell in the rebuttal. What your viewers need to know is you can't give a 1-hour opening as the prosecutor and a 2-hour rebuttal. It just doesn't work. I think this was a deliberate plan. Every prosecutor knows you do have to go through the elements. You've got to get that part down so that the jury knows how to fill out the jury verdict form. If you notice, they did not play very much of the tape at all. And I'm sure that's because the judge probably has told them in chambers, you're not going to play that tape all the way through twice during this. You got to figure out how you want to use it. So Blackwell is going to bring the tape in at the end. The other thing you did not see here today with Slisher's argument was you didn't see him take it apart on cause of death. You didn't see him go in. He did go through that, but it was while he was filling out the elements, not necessarily while he was just taking that on. So both of those tasks are left to Jerry Blackwell. And so while he was a little methodical at times, I think he did what needed to be done.
And Doug, Rena and Brock just talked about this a little bit, but now that they have this favorable instruction regarding the third-degree assault for the second-degree murder charge, do you think that the state has enough to convict on all 3 of these charges so far?
I do. I still share with Brock, though, that I think the second-degree murder, here it is, unintentional murder, but you have to find an intentional felony in order to do it. I think the jury can get over that, but that was one that I thought that Schlischer really needed to lay those elements out and get that down for the jury, because that's just a little counterintuitive for them.
All right, Doug, we're expecting in a few minutes, any minute now, I should say, to go back to the court to hear the defense's closing arguments. What do we expect there? If anything, will they, obviously he's taking notes and he's writing things down, but he has something prepared already. What can we expect?
Yes, I think he will have thought and anticipated Schlischer's argument. So he is going to go straight to the elements, and he is going to say, here's the element, this is cause of death. And then he's going to go through all the evidence that he has. He's going to talk about Fowler. It'll be very interesting. I expect that we will hear a lot about Dr. Baker here, and what Dr. Baker's original view was at or around the time he got the toxicology report, when he was interviewed by the FBI. I think we're going to hear a lot about Baker because I think Mr. Nelson has put most of his eggs in the basket of cause of death, and that's what you're going to hear a lot of coming up.
And Doug, so just so our viewers know here, we're awaiting Eric Nelson giving his closing argument for the defense, and then Jerry Blackwell is going to deliver a rebuttal for the state. The judge will read some remaining instructions to the jury, and then they'll begin deliberating immediately. When we talk about this rebuttal, you shared what you think Jerry Blackwell will do, but can you explain what are the rules? Like what is he allowed to do with a rebuttal? And you mentioned it can't be as long as they went the first time around.
Yes, and it really does have to rebut points that Nelson brings up. And I think that's why that the prosecution has anticipated how that's going to go. And so they've saved those gems for Jerry Blackwell. And I think they've saved them for him to give them very succinctly and then end up by playing the 9 minutes and 29-second tape, which we all know is the strongest piece of evidence here. But Judge Cahill has been very precise about saying during the trial, rebuttal has to be rebuttal. You can't just repeat your original argument a second time. It really has to go to rebuttal.
Now, Doug, I know you know a lot of these attorneys personally, and you watch them perform here over on television this entire trial. Can you if you can, kind of weigh in on how each of them did with their differing styles? Obviously, Jerry Blackwell, very different style than Steve Slisher, and Eric Nelson, different from both of them.
You know, you got to give, when you step back, you got to give Keith Ellison some credit for recruiting talent to his team. Steve Slisher was one that the United States Attorney's Office went to on some of its most important cases. I negotiated with them about Jacob Wetterling. And so that was how important that case was to Andy Luger, who was the U.S. attorney at the time. And I think Schlisser has done a good workmanlike job making sure that the elements and stuff are in. Jerry Blackwell, also recruited to the team, has shown the ability to connect with folks, and we're not in the room, so it's hard to see how he's connecting with the jury. But he is a magnificent lawyer. I think he's done a really good job. Eric Nelson has had a tough sled, and he obviously hasn't had all the support. I think we've seen 5 or 6 or 7 lawyers for the state, and Nelson has done it all by himself. And if your viewers remember, I think it was the end of about Thursday afternoon of the second week, poor Eric seemed like he was just running out of gas. And they had that little kerfuffle about a document that he said he didn't get, and then he said he did get it. I felt for him because it is a lot of hard work, and to do that all on your own is really a monumental task. I think they've all done a good job. I think this trial, and the other thing is, I think Judge Cahill has to be congratulated for conducting a fair trial that everybody can see.
Doug, I'm so sorry, we need to cut in, but the court is back in session. We'll get back to that thought in a moment. Thank you. Let's listen in.